When I chose to sue Roger Ailes a decade ago, the idea of a national #MeToo movement was barely a rumor. I was a journalist at Fox News and I spoke with more than 20 other women about the harassment I had suffered. Within a few short weeks their stories came to light, and the headlines began to shift. Bill Cosby was charged, Bill O'Reilly's allegations became public, and women started to name Harvey Weinstein, Charlie Rose, Matt Lauer and so many others. The power of the hashtag, originally coined by Tarana Burke, was beginning to ripple across the globe, bringing uncomfortable truth into the public eye and demanding accountability. But the movement's momentum never stopped. Even as the headlines shifted from scandal to politics, the same names that were once thought to be beyond reproach continued to run for public office. Brett Kavanaugh was confirmed to the Supreme Court against a backdrop of vehement opposition to his handling of Christine Blasey Ford's allegations. Donald Trump was re-elected, carrying with him the scars of his own findings of sexual abuse. Pete Hegseth, who had settled accusations of sexual assault, secured a role as Secretary of Defense. The era of cancel culture had given way to a world where once cancelled men Louis C.K., Roger Ailes, Bill O'Reilly and more reclaimed their positions of power. The story that emerged was one of ongoing abuse, with #MeToo erroneously declared dead. In truth, the last 10 years have produced a legal transformation that will outlast any single predator's presence in the public eye. The crux of the movement's legacy has been the overhaul of the legal system that once allowed silence to thrive. Today, companies can no longer use non-disclosure agreements as a shield or force arbitrations that keep victims from speaking. That's because we succeeded in passing two pivotal federal laws, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act and the Speak Out Act, both signed into law in 2022. These laws make it illegal for firms to compel victims of sexual misconduct to waive their right to public disclosure or to resolve claims in private arbitration. State-level progress has also accelerated. 19 states now restrict non-disclosure agreements in the context of harassment, discrimination, or retaliation. New Jersey, California, and Washington have gone further, banning the use of NDAs for all workplace toxicities. That means in those states the employer can no longer keep a victim as the sentence truncated in the original, but the effect is clear: millions of workers now have a louder, safer voice. We've already seen cases where the new laws were invoked, like FKA Twigs suing Shia LaBeouf over an NDA that concealed what she described as abuse. And the broader cultural shift is equally significant. The enduring change is the acknowledgement that silence is no longer an acceptable path. I didn't write a manifesto, I wrote a witness statement. By filing my lawsuit, I opened a door, the rest of the movement stepped across it. My conversation with Julie Roginski, a former colleague, helped frame the arguments that led to the federal laws. Together we demonstrated that corporate silencing tools are not just morally wrong but legally unacceptable in a society that values truth and safety. What this story tells us is that one woman's courage can spark an entire movement that reforms laws and liberates countless others. And the final lesson, so often repeated in political circles, is that silence ends with simple, legal structures that force accountability. Let isolate the fight against workplace harassment from just politics, let it focus instead on solid laws that enable victims to do what they always did: speak up. Thanks for listening, and stay the course of speaking out.